Hi, I'm Lise Wheel. As you can see here, we have a break in the Tex McIver case. So it gives us a chance to comment on the cross-examination and also the direct examination of Danny Jo Carter. She's been on the stand here now. This is her second day. As she said just a moment ago, her brain was turning into a little bit of mush. So the judge is giving everybody a break. So it gives us a chance to digest her cross-examination and also to talk a little bit about what's been going on in the courtroom today. It's been fascinating cross-examination and critical for both the plaintiff, the prosecution, and the defense case here. Critical for the prosecution's case because, as you know, she actually figures in 2 of the 7 counts in the indictment here because she is the witness that the prosecution says that Tex McIver tried to tamper with, i.e. change her testimony, change what she had told the police. And also, she figures in very prominently in all of the counts because she is the only eyewitness to the crime or accident, depending on how you look at this. She's the only one that is in the car. In fact, she's the one that is driving the car. There are 3 people in that car, and she's one of them. There she is in cross-examination. I want to introduce here to talk to us about this my old friend, Bob Bianchi. It's great to have you here. You know Bob, of course, he's been a prosecutor, actually ran an office in Fulton County, I believe.
Morris County.
Morris County, okay. Got my counties wrong there.
Right.
And also a defense lawyer, so he's got both perspectives. So as I just said, she's critical to the prosecution because she was an eyewitness, the only eyewitness to this other than Tex, and has been on the stand and critical for the defense. What are you taking away from it in the sense that the defense is really honing in on the statement that the prosecution brought out yesterday, which was Tex said to her, it looks bad. The exact statement was, it looks bad. Let me get it here. This doesn't look good. This doesn't look good. And on cross-examination, they got into that. What does that mean, this doesn't look good? That's at the scene of the crime or the accident when Diana's brought in there and Tex says to her, this doesn't look good.
Lisa, I've been doing prosecution and homicide work for pretty much most of my career. And one thing that we know, as in the investigation stage or prosecution stage, is that people lie for all sorts of reasons that don't necessarily mean that they're guilty of a crime. And some of them lie for many reasons because it doesn't look good. It doesn't look good that we're cheating with one another. It doesn't look good that I have a gambling problem. It doesn't look good that I'm a drug addict. And they tend to sometimes change their testimony to avoid the embarrassing aspects, but that doesn't necessarily mean that they're a murderer because they lied. And I've seen that countless times, and investigators need to be very slow and very cautious before they make a jump that a lie means that the person committed the crime. And that's kind of what I see here. And you know what? This is what I'd be saying, and I think this defense has done a great job. As a prosecutor, if I were sitting in that courtroom prosecuting the case, while I may look stoic and like nothing is affecting me, I am really concerned by this woman's testimony. And the prosecution is the one who put her on, because what's at the heart of this case is the prosecutor indicating that what we perceived as an accident first, and that's how we viewed the case, all changed when we had quote-unquote motive, i.e. the financial issues with the will. But like we were talking offset, all prosecutors love motive. You don't need motive,
don't need it,
but you love it. But that motive has to be ironclad. And in a financial crimes case, you have to show that there was significant upsetment of the person, or that that person had said to people, or that person was like agitated or upset. What we're going to hear in this case, if the defense's opening is accurate, is that not only was he not upset about this, he was actually trying to push forward via email, getting that second will that can't be found completed. In other words, to get it done. And so this whole cockamamie case in my mind, and I mean this as a prosecutor, I'm looking at it from that perspective, is then we find out that he's driving in the car. He decides to commit this murder with the best friend driving the vehicle.
The best friend of Diane, not his best friend.
Of course.
Her best friend,
Of course. And so when you go back to that thing about lying, and that's what the prosecutor wants to say, I think jurors are regular common sense people people are a lot smarter than the lawyers. In my opinion, it's been my experience. And collectively, they're going to understand, yeah, well, you know, people do lie for all sorts of reasons, but let's go back to common sense. Why would it be that he would say, I'm going to orchestrate this murder with a witness in the car? And by the way, Lise, I say there's a second witness in the car. The victim herself.
All right.
And the victim herself, and this is going to be compelling testimony, who was there, who knows the relationship, who knows about the will and the finances and all the la-di-da. You have the girlfriend, the girlfriend of the victim saying, great relationship, loving relationship.
Right.
They were two peas in a pod. Then you have the wife who was right there, who handed him the gun.
Actually takes it from the console in the front of the car and hands it back to Tex.
Yeah, I mean, this has got to be...
Actually hands him the murder victim, if you will, if you take it from the prosecution's perspective.
Right, you would have to think this is the craziest thing in the world. So the guy's got a gun in a bag in a console.
Right.
Unbeknownst to him, while he's sleeping in the back seat, they wake up because they choose, the two ladies choose, to go off on that ramp. He says, wait a minute, I'm a little concerned about where this environment is. Hand me the gun. It wasn't like he had the gun with him. This was his plan, Lise.
Now. But let me take the prosecution's perspective, because you know that I can do that very well, is that that's actually the best way to plan a crime, because you don't want it to look like exactly that argument. Like, why would I? Of course I wouldn't have planned it. That's exactly the argument that a great defense lawyer like is going to come and say. Of course, it looks so silly. Of course I wouldn't have planned it like that. And you also know, so that's one defense right there. Of course, it's just exactly that. And the second argument is, as you know, intent and malice and forethought can be done in an instant. It doesn't have to be weeks or days on thought. It can be just in that instant. Text something snaps, and he says, now's my time.
But in those cases, you just hit it, and I agree with you. Your legal analysis is spot on. But some precipitating incident has to happen where the person snaps. They see their spouse in bed with somebody. They're in the middle of an argument. I had one in which they thought the guy found out that she was pregnant and thought that the best friend was the one who made it. That there was a precipitating event. Here, there was a guy sleeping in the car. You would have to find the precipitating event was he was so agitated that they got off the road that he said, hey, give me the gun. I'm going to kill you. Look, law comes down to, and my dad's 86 years old, and he instilled this in me from the very beginning since I was a pup trial lawyer. It's about common sense. Just because, you know, does it make sense? Does this whole thing resonate? And that you would then get a gun and shoot it through a plastic bag, through a seat, which could be deflected by all sorts of framing and so on and so forth, and then it would hit her lower end of her back, right by a hospital.
All right, then let's go back to this. Doesn't look good then. If that's all true, let's play it out the defense perspective. If you're right and it's just cockamamie and it doesn't make sense and the common sense, he wouldn't have planned it, why then would his first go-to reaction with the best friend have been that statement, this doesn't look good? Why would he be thinking about himself? Now, I could also say this doesn't look good, meaning her. She doesn't look, her health doesn't look good. She doesn't look, but let's say it's about him. Why would that be his first go-to response? Why would it be this narcissistic, it doesn't look good for me, therefore you may need to change your story, therefore I'm calling my lawyer? Why would it be that if he's so innocent?
Well, you know, she made an interesting comment. She made an interesting comment that at first they thought by the doctor's statements to them that she was going to be okay. Now, he's a lawyer in a car, and no matter whether he meant to kill her or not, he, in fact, shot his wife. And no matter how you look at it, even if it was an accident, it's not going to look good. These are two prominent people, and this catastrophic thing happened. And he's not stupid as a lawyer. In fact, I would be emphasizing that as a defense lawyer. He knows, the lawyer knows, that by the mere fact that it was even an accident is still potentially a crime of recklessness with regard to a discharge of a weapon. So, I mean, and they're high prominent, highfalutin people in their social world that at least a guy like me doesn't socialize with. It's not going to look good that you were stupid enough to fire a weapon in a car that wound up hitting your wife in the back. It doesn't necessarily mean it doesn't look good because, you know, I meant to kill her right in front of you. I fired one round into a seat. Maybe it hit her, maybe it wouldn't hit her, and now that means I'm guilty of murder. I think the prosecution's stretching here with this evidence.
Okay, let me just follow up on this, and we'll go to a clip in a second. Let me follow up on that just for a second. Do you think that's why, in this 7-count indictment, they started with the murder with the intent charge, but then went right down to the aggravated assault with a deadly weapon, thinking they may not get that intent, but thinking they'll get the aggravated assault?
Well, see, here now you're asking a great tactical question. As a prosecutor who's been in front of a grand jury thousands of times, I would not have put aggravated assault in an indictment that I'm trying to say was a purposeful murder. Because it gives a defense lawyer the opportunity. This is what I'd be doing as a defense lawyer.
Right.
Well, what is it, folks? First, it's an accident. Then they go to the grand jury. Then it's a murder. But if it's not a murder, then
it's like settle on this.
I would call it. This is the Chinese menu of selections for you. It's an accident. It's murder. If it's not murder, it's aggravated assault. They have no theory of the case. They've twisted it and tortured into this financial motive. Not guilty.
And you've got to have a theory of the case, guys. When you're a prosecution, you do not start your opening statement without a theory of the case. You've got to know where your bricks are going before you lay down that path.
Amen.
Speaking of that path, let's look at some of the cross-examination from earlier today of Ms. Carter. She's a critical witness, actually, for both sides.
Correct.
Now, the ranch is 80-some plus acres, 100-some acres. It's a big place, correct? And folks would gather there for events.
Yes.
And there were at times kind of like hunting events, right? Sometimes there were politicians, sometimes there were folks that came there to skeet shoot or target practice and other events, correct?
Yes, not really hunting on the ranch.
And that's my mistake.
Okay.
Target shooting at clay pigeons,
yes,
and those kinds of things.
Yes.
And when those folks came to the ranch for those kinds of activities, there were guns there that those people that came for these events could use, correct?
Yes.
And those were some of the weapons that were inside the safe and at the ranch, correct?
Yes, yes.
Okay. And you also told us about this shooting mound out there.
Yeah.
People would go, you included, Little Austin included, Tex included, would go and shoot into this mound, correct?
Correct.
So there was plenty of woods out there. There were horse trails and people could horse ride. People shot weapons out there, including Tex and you and other people way out there in Eatonton, an hour and a half from here in the middle of the woods, right?
Right.
There was also a swimming pool there, correct? Yes. And people went swimming there as well.
Yes.
Okay. Did you often take your swimming trunks and go swimming when you went out there during the summer, for example?
Occasionally.
And oftentimes, sometimes you wouldn't even come back on Sundays, right?
Yes.
You'd stay out there on Sunday night over to Monday, if conditions allowed.
Yes.
And come back maybe Monday.
Monday
right?
morning, yes.
Right. So that at this particular point in time, and we're talking about September of 2016, I understood.
Hi, I'm Lise Wheel here with Bob Bianchi. We are waiting for the jury to come back in. And on the Tex McIver case, let's see. Looks like the jury is coming back in. So we're waiting. We're probably going to have Ms. Carter back in for more cross-examination from the defense. She's the critical witness in this case. I mean, absolutely critical as the only eyewitness to the case. We're going to toss to her in the cross-examination, the continuing cross-examination of Miss Jo Carter.
You were in the midst of your cross-examination of Ms. Carter. She's back, and so are you.
I think we had finished, Ms. Carter, with your 109 interview at Atlanta Police Department. That interview ended. No, I'm going to wait because we don't have the report.
Whoops. Hey, how are you? It was about 5 minutes ago, but it's all good. Don't worry. We had just made sure everyone was in position. Let me know when you're ready.
Okay, second. I'm ready.
Okay. Welcome back, ladies and gentlemen. Mr. Harvey is now about to recommence his cross-examination of Ms. Carter.
Take two.
Okay.
We had time. I'm gonna repeat though. All right.
This one's okay.
All right. We have just finished talking about your interview at 1:09 a.m. on the morning of the 26th. Okay. That was when you had first come back to APD. You were brought into an interview room and you talked with them for about 10 minutes. Correct?
Yes.
Someone either got a text or a call, and the two gentlemen that you were talking to left the room.
Yes.
Okay. And that would have been, would you disagree with me, that it was approximately literally 10 minutes after the interview started?
I would not disagree with that.
Okay. And then you told us that there was a lengthy time that you were left there by yourself.
Yes.
Okay. And you know, you were informed that Diane had passed, right?
Yes.
And here you are, her best friend, in an interview at the Atlanta Police Department, left by yourself, correct?
Yes.
And it was clearly an emotional time for you, right?
It was horrible.
Right, especially being left alone there.
Yeah, I was scared down there. I mean, because it was an empty building, a big empty building.
And really, from about 20 after 1 till, and again, would you disagree with me that your second interview started at 2:39?
I certainly, I wouldn't disagree. I don't have any idea because I had been crying and I wasn't sure why I was still alone, and I didn't know I didn't know why I was still alone. And I didn't like one of the policemen that was trying to interview me, so I didn't want to talk to them again.
Okay, I'm sorry. That was a multifaceted answer.
Okay.
And
The last part kind of trailed off.
Yeah.
She didn't like one of the police officers who had been interviewing her, and she didn't want to talk with him anymore.
Okay. And you didn't have to, correct?
That's correct.
'Cause
I didn't know.
Right. They
Yes.
left.
Yes.
And I'm just trying to get
Yeah.
this gap period because I know it was difficult for you. You're sitting in an unfamiliar place and essentially in police custody. You can't really go anywhere. You can't really do anything. And you just got some of the worst news you've ever gotten.
Yes.
As you sit here today, has he ever told you whether or not he actually did it?
No.
But he asked you to go with him to have it done?
Yes.
And when did that occur?
I don't know. I don't know.
And so when he asked you to go with him to have his will revised, what did you say?
Well, at first I said yes because it was easier to say yes and then not say no, and I was kind of curious what was going to happen, and then I called my attorney and asked him what he thought about it, and he said...
Don't tell me what he said.
Okay.
What's the name of the attorney you called?
Lee Davis.
Okay. And when you spoke to Mr. Davis, did you go with Mr. McIver to have his will revised?
I did not.
You did not. Okay. Now, let me ask you, when you told Mr. Harvey that Tex wanted you to tell him what you remembered, you remember that?
Yes.
Speaking about the day you were in the bedroom at the condo, he had the legal pad.
Yes.
Right? And would that have been the first time that you would have shared with the defendant your, as you call them, memories about what happened?
Yes.
And you remember that that conversation with him in the bedroom occurred on what day?
Tuesday.
Tuesday. And to the best of your information and knowledge personally, do you know whether or not the defendant had spoken to any law enforcement at that time?
I didn't know.
You didn't know?
No.
While you were at the hospital, did he speak to any law enforcement?
Not that I was aware of.
I got a lot more. And I'm not going to be able to finish. It's already 5 o'clock. I'm going to ask for a little indulgence just so I can kind of wrap my brain and perhaps structure my redirect a little bit better so it'll go a whole lot faster if we could reconvene tomorrow morning.
Well, we will for sure be reconvening tomorrow morning. Unless you're about to announce you're going to arrest, and then who knows what the defense will do.
No.
But I know better than that. All right, it's 5. You all, jurors, have put in another long day, as have you, Ms. Carter. So let's do this. First, Ms. Carter, you are free to go for now. We'll need you back at 9 tomorrow, okay? We'll talk about the case with anyone between now and then, okay?
Yes, that's what we're wrong.
That's all right. So we'll see you tomorrow. Jurors, let's talk scheduling for a minute. It is my understanding that Saturday is a non-starter for any number of reasonable possibilities. You don't need to articulate them. But you guys are working hard to line up days where you could stay as late as 6 fingers. That would include this Thursday and next Tuesday and next Thursday. So we've got at least 3 days where you all can stay at least until 6. And
I'm Lise Wheel, and I'm back with you now. The court has convened for the end of the day here, or has ended for the day. That was a very long redirect, a tennis ball match between the recross and the redirect of a very important witness here, though, Ms. Carter. Tell us what was the best thing, and I put that in quotes, of the redirect, Bob Bianco.
I told you before, the thing that was unbelievable the prosecutor did was with all that technology and pictures, he had that little wooden pointer with the rubber tip from like the 1950s.
Yes.
I was impressed with that. I like that. But other than that, this is prosecutorial malpractice. Redirect examination is an art form. You're not befuddling and moving around. On direct examination, you want to know exactly exactly where you want to go. You don't want to reiterate her story, and he's clearly, it was almost like it wasn't his witness, like he was cross-examining his own
almost
witness.
was like an adverse witness, almost a hostile witness, it seemed at points. This is his witness.
Look, when we would train our trial lawyers as prosecutors, you have to know that you need to say something on redirect that's very important, very specific, right to the point. And maybe you want to do a little bit of this. If you're really nuanced as a trial lawyer, you may want to be able to say, did I hear you correctly when you said that the knife was plunged into his body multiple times?
Can you show us again how it was plunged?
And I'm not really sure if I understood what you said when you were saying, I want to kill you. But you don't go in that in other words, you're repeating the good parts of it with the question of a clarification.
Emphasize that again.
But short, brief, to the point. In fact, less is more. And this guy now has to say at the end of it, it was just horrible. I had the goosebumps. Can we come back? Because I'm really not prepared.
And confusing. Now that she's got to come back for a third day. She said she was tired already. I think the jury is tired. Then it went back to recross. And then there was a point there where he was talking to her about where the lights and all of this, and she looked confused. This is his witness. This is his key witness, the one eyewitness there to what he's calling a crime as opposed to an accident. I think he was really hurting, and I think the thing that really showed here today is he lacked a theory of the case. He almost seemed like he didn't know where he was going with this witness.
He's shooting at the Wild West, and he's trying to make up and pull strings, and every time he did it, he hurt her. She hurt him again with the answers. But like you're saying, he's not moving the ball forward over the goal line to prove beyond a reasonable doubt. It's not just in what was said. It's the manner in which he's doing it, which is demonstrating to the jury these guys don't have their game squared away, in my opinion.
That's a problem. Bob Bianchi, thank you so much for being here with us today at Law&Crime. I'm Lise Wheel. I'm signing out for today, but please join us for more tomorrow. We'll be here on the Tex McIver case, live with more testimony, cross, recross, redirect, will it ever end? With this witness, Danny Jo Carter, will be back tomorrow.